Welcome, folks, to another episode of Exposed Vet Productions Weekly Show. My name is John Stacy. They call me jbasser. My co-host today is Mr. Ray Cobb out of the great state of Alabama, or Tennessee, the way you want to call it. He lives out on the Tennessee-Alabama line. He can step one way and be in Tennessee and fall back into Alabama.
There you go.
Today,
That's the way it works down here.
trip over logs.
Yeah.
No.
Yeah.
Today we got a treat for you today, guys. We got Mr. John Dorle. He is an accredited VA Appeals Agent. He has a plethora of experience doing this. He started out working for, I guess, the county veteran service office back when he first started doing this many, many moons ago, probably 30, 40 years ago. So he's been doing this for a long time. But today we're going to start off. We're going to get the state of the VA. And John, what do you think today's state of the VA is? I guess we're doing from the regional office side, from the claims side.
Yeah, as I was talking to you earlier, I think it's always a good idea to kind of, at least from my perspective, the state of the VA, the good, the bad, and the ugly. I think the bad and the ugly is pretty clear. That's always been the case ever since I started in 1992, is the delay until the veterans quit. That seems to be the running mantra with the VA. But yeah, it's continuing to be a delay process. But one thing I can report, the Board of Veterans Appeals has gotten a lot better as they whittle down their priority had always been the legacy appeals. And for those people that remember the legacy appeals, that was the appeals process prior to the current Appeals Management Act. But they've whittled down the legacy appeals process to the level that it's not nearly as bad anymore. So in the day, probably as recently as a year and a half ago, it was about 40 months. 3.5 years for a decision to come from the board. But as of late, within the past 3 to 4 months, I've been seeing decisions coming back in 8 to 12 months. So that's wonderful. And the decisions are good. I'm getting some good decisions from the board. So that's the good. But of course, with the what I mentioned earlier, the delays are never good. But as many of us are aware, the VA will expedite your claims if they can show financial hardship or terminal illness, or if their age is 85 years of age or older, if they're at the local VA, and 75 or older if it's at the board. So that's kind of in a nutshell of at least my take of what's going on with the VA. It continues to be a process, and we just whittle down the claims and win as many as we can from this end of it. So yeah, any questions at all? Can't hear you.
We know there's 3-level appeals of the VA.
There we go. I can hear you now. I'm sorry, I didn't hear you.
You got the
First
direct
few
docket.
seconds I didn't hear you. Go ahead, ask your question again.
Well, go ahead, John, whichever.
No, I was going to say there's 3 levels of appeals to the VA, and each one had a different time frame, and they'll get some done because of I think the quickest was used to be they take a trip to D.C. and do the appeal, and then they had the direct docket review that I had. And I think about it takes about 40 months, something like that, if I remember correctly.
Yeah, that's what I was referring to. The direct docket review is about 40 months out, and even longer for a personal hearing. Then there's the other option of a 90-day admin review to submit new evidence. You can just add 90 days to that. But direct review is about 40 months. And like I said, it's not that long anymore. I think that's as a result of they were able to eliminate the legacy appeals to a large degree, so they can concentrate more on the AMA, Appeals Management Act appeals. But about 40 months, probably a couple years ago, was at about 40 months, and it's gotten a lot better. So
Good. All right, guys. Remember that if you're in the appeal process, you're waiting for a direct docket review, and you just got some good news there. It's going to be a little quicker than what I had to go through a couple of years ago because it was a discombobulated mess, in my opinion. So, but
Yep.
John,
John.
do you think right now what's going on? I got a call today from a veteran, and fortunately, one of my friends referred him to me. That's a doctor, and the interesting part about it, he had been told by the county service office to go ahead and file a claim for loss of use of hearing. He was around jet engines all the time in the Air Force back during the Vietnam era. Well, the problem with that, when I talked with him, he has no diagnosis. And I'm wondering, why are these county service officers in Tennessee and probably around the entire country telling people to file a claim when they don't even have a diagnosis yet, and the fact that it's not going to do anything except setting up delays and bogging down the system. Do you think that's what they're trying to do?
Well, I think what the county service officers are trying to do is at least in the day I was a county service officer for about 20 years, and I started doing this independent for about 15 years now. Um, if I had a veteran that came to me, and one of the first questions I'd ask them is how their hearing is. I could usually tell by just talking to them. I'd know what the answer would be, but I need to get the veteran to admit that they have a hearing loss. A lot of times they'll have their spouse with them, and the veteran might say, "Oh, my hearing's fine," and the wife in most cases will be looking side eye at the veteran like, "No, it's not." And so to answer your question, once I've determined that they have a hearing loss, I absolutely file a claim for them, even though they don't have a diagnosis, because most of the time, veterans who are suffering from hearing loss, they don't have a formal diagnosis. So if they don't have a formal diagnosis, that's not going to prevent me from filing the claim. And
Mhm.
and honestly, Ray, that's part of the program with the VA is those compensation exams. They will get them in for an exam, and they will diagnose them or not diagnose them. So
Mhm.
don't feel like they're trying to bog the system down. I think what they're trying to do is the same thing I would have tried to do is get these guys service connected to hearing loss or even ringing in their ears tinnitus. Um, I think it's important to file the claim, let them do the compensation exam, and let the audiologist determine whether they have a diagnosis or not. Don't don't place the onus on the veteran to go get a diagnosis and then file a claim. I think that would be the opposite of what I'd want to do.
Okay.
Nothing diagnosed. But would that not negatively affect his dates? Say, for example, if he didn't have a diagnosis, but he goes to a C&P exam after stay, files his claim 6 months later, just generalized date I put in there that he goes for a C&P exam, and next thing you know, he does have compensable hearing loss. Well, they will probably take advantage of the situation there and say, okay, your effective date for the hearing loss is the date of your hearing test. Film at 5.
Well, we're assuming that initial hearing exam was 100% accurate too.
Mm-hmm.
I think that I get your point. I think the point is that do we want to put the cart before the horse? Do we want to rush them in for an exam without a diagnosis, and then they go in, they don't have a diagnosis, and then you file a claim a year later, and then they have a diagnosis, and then the VA comes back and says, "Well, whoa, you didn't have a diagnosis a year ago, now you do." So
Mm-hmm.
something happened within that year that caused the hearing losses. It wasn't the military. So yeah, I mean, it is strategic. Um, I like to strike while the iron's hot myself. If the veteran feels like they have a hearing loss, to me, 99 times out of 100, they have a hearing loss. Now, if they're kind of
Mm-hmm.
up in the air, they don't know if they have a hearing loss. Sometimes they hear things, sometimes they don't. yeah, then that would be a time maybe to go get a diagnosis first, because then we don't want to fall into that
Hmm.
trap of, you file a claim
Hmm.
today, uh, your decibel losses are low, and then 5 years later you file a claim and they're off the charts, and then it's hard to point the finger at the military. So I get your point. Um, my theory has always been, like I said, strike while the iron's hot. The veteran and the wife, the spouse, usually knows whether they have hearing loss or not. So I've never been one to delay myself.
Hmm.
I don't know that I
Okay.
can ever remember a case where that kind of bit the veteran in the hind end, you
Hmm.
know.
Right. All right.
And even if it
Great.
did, we'd have to put, the VA would have to demonstrate that that audiology exam they had at that time was in fact accurate as compared to the one they have a year later. So,
Okay.
yeah, I
Uh,
think the risk reward ratio is more in favor of the veteran. Just get the claim in, let them get in for the compensation exam. Yeah,
all right. Ray, I'm going to send you a BVA claim here case tomorrow, maybe the day after. When you get it printed off, we give it to the guy. You said the
Okay.
guy was the MD, or MD, medical doctor, right?
No, that's who referred him to me. The gentleman is 79, almost 80 years old, and
Okay.
he's never filed a
Okay.
claim. He's never,
Hmm.
he's to the point where he's thinking he could possibly use some medical assistance. Now,
Yeah.
the other question I have, I saw this happen once. I took a veteran down to the Alvin York to put in for medical. And he goes in and the guy's going through all the numbers and everything. He said, well, you don't quite qualify. You make too much or your retirement's too much. And then the guy says something, well, when I was in Vietnam, he said, wait a minute, you were in Vietnam? He said, yeah. He said, well, then you automatically qualify for medical. Is that
Hmm.
true? So if he served during the Vietnam era, then he
Hmm.
automatically qualifies for medical, right?
yeah, John, I think you
Yeah.
agree. I mean, there's a difference between Vietnam era and in-country Vietnam.
Yeah.
You have, and really what, like I said, when I was a county service officer, these are the types of questions we'd have as county service officers. It didn't necessarily fall into the disability compensation part of it. But from what I remember, and I don't think the law has changed, you're in a protected category if you served in Vietnam because of your exposure to Agent Orange. That
Hmm.
automatically enrolls you into the VA medical. Well, I mean, you have to get enrolled, you have to fill out the paperwork, bring your 214 in. But I mean, your exposure to Agent Orange, as far as I remember, John, you tell me if I'm wrong, but as far as I remember, you're exempt from the means test with the VA Medical Center if you can show Agent Orange exposure, and that would even
Hmm.
any type of Agent Orange exposure, Korea, Vietnam,
Anyway,
airplanes that carried the Agent Orange, that kind of thing. So, um,
get
Atomic
on the
Gun.
registry. Get on the PACT Act and Agent Orange registry. So to get on the registries and they'll do that. But no, he should be getting free medical care. I mean, as far as that, he might still have co-pays to pay. But anytime you're
Yeah.
involved in herbicides or testing like that, it's the same thing as the Project Shad people, like girl.
Well, he was around a lot of jet fuel. He was a he was
Hmm.
a he was a mechanic, and he worked on
Hmm.
the motors, jet motors. So
Hmm.
he said, "Oh yeah, I was around fuel every day." So I don't, but he doesn't have any cancer. His hearing from being around the engines is really his only. From what he told me today, it's the only thing that I recognize as being a disability that he may be entitled to. Um, spending 6 years working around in the Air Force, working around jet engines.
Yeah. But
Yeah, yeah, Ray, he should definitely, and at that age, he could rate real high for hearing loss,
all
and
right.
then
Plus,
automatic 10% for tinnitus.
Well,
Uh,
and he had to ask me a lot of times to repeat what I was saying, and
Mhm.
I'm not for sure if his hearing was a point that he couldn't understand what I was saying, or he actually was dropping off words, so he didn't
Well,
understand what I was saying.
given his age, go ahead and get the claim filed. Help him do it. Get it turned
Yeah,
into him.
that's
Let them figure it out because he goes to the top of the line. He goes to the head of the head of the train. He gets to ride in the engine.
well,
Given
and
his age.
that's what I told him, and I also told him
Mhm.
he likes his. He's actually from another county, Coffee County, up the road from us here in
I know.
Manchester,
Okay.
and he likes that county service officer. They have a new one up there. He's been around only a couple of years. So I said, if you feel comfortable with him, if you think he's doing you a good job, go see him.
yeah,
Hmm.
yeah,
At
yeah,
least he gets to ride up
wholeheartedly.
front. The rest of
Yeah.
us get a ride hanging on the caboose with maggots on our feet.
You get rated for hearing loss. You get rated for tinnitus, and given his age and his poor hearing, I suspect he could get rated pretty high for hearing loss. Automatic
Uh-huh.
10% for tinnitus. Uh, and I can, a lot of veterans aren't comfortable with it, but when they hear so poorly, it causes them depression, anxiety, anxiety in the
There you
sense
go.
they get worked up because they don't think people are going to hear them, or depression because they can't associate in society the way they want to. And you can get rated for that for depression and anxiety as well. Um, and then you get rated for depression and anxiety. Typically, the older guys have sleep apnea. You can see how the gears are turning.
Yep.
This guy's 100% permanent total waiting, right, John?
He's waiting in the wings for 100% firm total, but he's got a very short period of time to do it. And it's nothing to do with VA claim. When you get that age, you better get her done because you know that time is not on your side,
Yeah,
especially if you got a wife
Just
and DIC and things like that. You know.
his wife has passed away already. He's 79 years old. So, I mean, he's really, for 79 years old, he sounded pretty good. Of course,
He
I'm
needs to go out and marry a
76,
30.
and
He needs
yeah.
to go out and marry a 30-year-old and put her on, get 100% and
Mm.
let it keep on giving until she passes away in 50, 60 years. So,
Get some of it back.
that's what I was thinking. Yep.
Uh,
No, that's a good question, Ray. I think in general, your county service officers they try to do right by veterans, but like John said, there is strategy there, and he makes a good point. Yeah, sometimes you can shoot yourself in the foot by filing a claim too soon, as opposed to waiting till you're like 79, 80 years old, because it's a lot easier to pin it on the military as compared to working in a mechanic shop for the past 20 years. That kind of thing. Not that we're trying
yeah.
to cheat the VA or anything like that, but I think that you know we need to give veterans every advantage that we can, and reasonable doubt. You point the finger at the military every chance you get. So it is strategic as to when you file a claim, but I think at the age of 79, uh, that's a no-brainer. Yeah, he needs to file a claim, and like I said, it's quite possible he could get rated real high for it, given his poor hearing.
Yeah, I feel like he would.
Yeah. I hope the county service officer feels that way too. Some are really good, and some are, I don't know. So I had a little bit of a war story. I had a veteran gal, call me the other day, uh, wanted me to represent her, and I explained to her. I said, I'm not taking cases anymore, but um, I'm looking to retire in the next 4 years or so. But I'll get you in line. I'll get you hooked up with someone. And she was out of Texas. And not to pick on Texas, the Texas Veterans Commission are very good when it comes to representing veterans, but Not this time, unfortunately. Um, they ran her around and she was crying and she just was suicidal and the whole thing and they just didn't give her the TLC they needed. So I ended up taking the case and so we'll see what I can do with her. But I guess the point I'm trying to make is that as in with any profession, my profession or anyone else's, there's good advocates and there's not so good advocates. So if you're listening to this podcast, um, just remember that if an advocate tells you no, don't take it as gospel. Look at every avenue you can. Do your research. Talk to other advocates. Talk to your friends. Talk to your family. Um, get the claims in. Worst the VA can do is say no. At the very least, you get a decision. You have a year to appeal it, and you can build on that. Once you get into an appeal status, you get uh, plenty of attorneys and claims agents such as myself that probably be more than happy to take the case. But don't hesitate in getting your claim in. Like I said, the worst the VA can do is say no. They have to go into detail as to why they say no, and we can build off of that as a power of attorney.
Okay. Uh,
So,
it's nuts.
as far as timeliness, guys, I guess I could build a little bit on a little history on the appeals process. I like to think
Hmm.
that's my swing zone, but in the day, I talked about that earlier. We had the legacy appeals process. It switched over to the Appeals Management Act, the AMA, probably around 2018, 2019. Uh, it's a whole different way of doing things with the VA as far as appeals. Uh, when you get a decision from the VA and it's a denial or if it's a grant but not rated as high as you want, uh, you can always appeal that decision. There's three different types of appeals. You've got the supplemental lane review, the higher level review, and the Board of Veterans Appeals. So a supplemental lane review is basically you're telling the VA that I have new evidence that you haven't looked at before. I'm going to supplement my appeal with this evidence. I want you to make a different decision. Or you can go a higher level review where you say, I don't have any new evidence, but I think you applied the law incorrectly, and therefore I want a higher level review. And this is a decision review officer in what's called a DROC. There's three of them in the country: St. Petersburg, Seattle, and Washington D.C. DROs, DROs, they're called, are higher level raters. They've got more seasoning. They don't always make the right decision, but they have more seasoning. So under a higher level review, you can have a DRO look at your case. The third option is you can skip both of those and go right to the Board of Veterans Appeals uh, and get a decision from them. I don't typically go to the Board of Veterans Appeals right away. I do a higher level review before we go to the Board of Veterans Appeals because, like I said earlier, uh, the wait time 7 to 12 months now, which is still a lot, but not too bad. But up until about a year ago, it was about, like we mentioned earlier, about 3.5 years. So I avoid the Board of Veterans Appeals as much as I can just because of the wait. If we can win it under a higher level review, that gives us another swing at the plate. And then if we have to go to the Board of Veterans Appeals later, we can do that. So that's kind of it in a nutshell on the three options you have when you get a decision from the VA. Now, the time frame for supplemental lane reviews is about 125 days, depending upon the complexity of the case. And the same with the higher level reviews. The VA's goal is 125 days, which is not too bad. But I think that I'm seeing these types of cases coming in at about 125 days. They're sticking to that as much as they can. But again, that depends upon the complexity. Um, One other thing that I should mention is the VA came up with this what's called a claims accuracy review. We call a CAR. Uh, when you file a higher level review, and if you feel like as the advocate that this case a slam dunk, case closed, you can label it as a CAR, claims accuracy review, and the VA is obligated to adjudicate that within a month. Um, Not everything qualifies as a car. But that's another option that we as advocates, we use to help expedite claims. Um, so most veterans aren't aware of that, but I think that most experienced advocates or powers of attorney are going to be aware of what a CAR, claims accuracy review is. So that's another tool that we use as advocates to try to expedite claims. Then, of course, like I said earlier, I mean, the standard expedite is always the case if your case is at a local VA regional office, it's you're 85 years of age or older, they have to expedite it. If it's at the Board of Veterans Appeals, it's 75 years of age or older. And then under either scenario, you have a financial hardship, a threat of homelessness, that type of thing. That's the expedite. Or if you have a situation where the veteran is terminal or in very, very severe health, they will expedite based on that too. I'll give VA credit when we can demonstrate an expedite, they do get on their horses on that. I think they do pretty good about that.
Uh, quick question. On a higher level review, have you noticed the percentage, or do you have any idea about how much of a turnover that's granted on the veterans that go the higher level review versus one who does a supplemental claim?
I don't have any statistics, Ray. I just don't. I go with my gut on that. Um, my theory is this: when we get a decision, and I'm talking to a veteran about it, um, the first thing I do is I try to see if they can produce new and relevant evidence. If they think they can, or if they want to go see a doctor for a medical opinion, Nexus medical opinion, or if they've got some medical records they think that will back them up, then I would do a supplemental lane review. Um, because what that does is it gives us another swing at the plate before we have to go to a higher level review. Um, but if the veteran says, John, I can't get anything, I've tried, I don't think I can get
Yeah.
everything, uh, but I would like to appeal this. I'd say, okay, well, let's strategize this. We can do a higher level review. We've got 8 issues. I see at least 3 of them. We can go to a higher level review. I really think the other 4 or 5 you're going to need new and relevant evidence. We kind of huddle up and strategize those types of things. But if a veteran tells me I can't get any new evidence, then we do go a higher level review. Um, but as far as statistics, numbers, as far as the win percentage on a higher level review as compared to a supplemental lane review, I think it's just too varied because with a supplemental lane review, it's introducing new and relevant evidence. And we don't know what that kind of evidence would be. It could be really weak evidence that the VA is still mandated to make a decision, or it could be really, really solid evidence. So those percentages vary in those cases as well. Um, I think the better question might be the difference between a higher level review and a Board of Veterans Appeals. Under a higher level review, you can't submit new evidence. Under a Board of Veterans Appeals appeal, under a direct review, you can't submit new evidence either. So that then we're on a firm playing ground, meaning what's better, higher level review or Board of Veterans Appeals? Like I said, I always go higher level review first because it gives us another swing at the plate before we have to go to the Board of Veterans Appeals. Because if the Board of Veterans Appeals denies us, we're going to have to come in with new and relevant evidence to have it, looked at again. I mean, you're a bit more limited when you get to a Board of Veterans Appeals and you get denied. So exhausting your options with a supplemental lane review and a higher level review are best. And then, if need be, go to the Board of Veterans Appeals.
Unless someone is very sharp, I usually recommend that after they get their denial, even if it's obvious that they overlooked something in your medical records, which they have mine, um, I always recommend they get an agent at that time because you have pointed out some excellent things that an agent can talk to them about that a county service officer can't and won't, and you can kind of rationalize out which is going to be the best way and the fastest way. And I usually tell anyone that I've helped get started or that calls me about a denial that they've received, what should we do next or what can I do next? I usually start looking for an agent that specializes in that in order to try to get them on board and get them started that way. I just think in the way the appeal process works today, they need that extra help. I just, at least the ones that I have ran into, now I'm going to take back the fact that I've had 2 or 3 that I've talked with and I've referred to James Cripps's webpage, VA the Redneck Way, and they followed that script and done that, and then they've also looked at John's, and they win the first time around. Even 100% with 4 or 5 different problems, but the guys that you can kind of, I kind of evaluate what they need to do. Basically, if I'm talking to a gentleman that finished high school, and that's the only education that he really has, and the rest of it's as we say around here, back behind the barn, then those are the guys that I'm going to say you need to get an agent. In the appeals process today, regardless of which one, what I've seen that works, you almost have to write a legal brief or pretty close to it in order to win the case in a reasonable period of time. And I don't know of how many veterans especially let's say 75 and older, can actually do that. I mean, a lot of guys I talk with can't even use a computer. They're not even on VA.gov.
Yeah.
Mm-hmm.
So,
Yeah. Yeah, your point's well taken, Ray. I think that as someone who used to be a county veteran service officer, I hope I wouldn't have been judged by my peers. I certainly think that there are very good county service officers out there. There are very good national service officers out there, primarily with the disabled American veterans on a national level. But that said, and John Stacy, you know this, but us claims agents and attorneys, we have skin in the game. Okay,
Yeah.
most of us are veterans. We want to do right by you. I'm a veteran. I want to win the claim for you. But from a business standpoint, we have skin in the game. So it's our business incentive to win those claims. Whereas the free services, they're going to get a check every 2 weeks regardless of how well they do. So I think my primary incentive certainly is for the veteran, but to keep the lights on and pay the rent, feed the kids, I need to win these claims. So I'm going to do everything and anything I can do to win those claims. And that means research, always keeping my ear to the ground, networking with my peers, building relationships with the Department of Veterans Affairs, just knowing anything and every law, rule, and regulation that comes out. And I think most of your successful compensated attorneys and agents are probably going to say the same thing. We have skin in the game. It's our incentive to win it. And we're going to do everything we can to win it. Not only because we care for veterans, but because we want to earn a living. I mean, to put it blindly, that's exactly what we're looking to do, is try to earn a living, but we also want to serve our veterans as well. So I think when you, Ray, I think when you're saying that you should automatically always get an attorney or an agent, I think that's good advice. But I would also suggest that there are plenty of free services out there that they're very good. And like I said, when I was a county service officer, I worked with my peers. I worked with national service officers, and they were very sharp as well. So I think that veterans nowadays, they get a denial. You can have your cake and eat it too. You can save that 20% fee that I'm going to charge on your back pay and give services through your your free offices as well. You save that fee, and then you also get your maximum compensation as well. That's a possibility. It doesn't always happen that way, but you can have your best of both worlds and have your cake and eat it too, so to speak. But I think if you really want to hit the nail on the head, you're going to want to get someone with my experience, or someone equivalent. I mean, there's plenty of law firms out there that are well established, uh, that would be more than willing to hear your case. What I am seeing though, Ray, is that a lot of law firms, they're not going to take every case, and unfortunately, some of them are only going to take the big buck cases, the ones that have been pending for a very long time, the ones that they have a very, very good chance at winning. And so, that's unfortunate that they don't take those cases that is going to require you to roll up your sleeves and get into the mud with the VA. But there are law firms out
Yep.
there that will fight for you. I believe. I know I would. So.
We call that cherry picking.
That's some great points. I mean, it's I can name one national service officer down in Nashville in the Nashville regional office. I think she's great. She helped me win my first Agent Orange case exposed in the United States. And she's helped me with other cases. And then as time went on and I went to a higher level, I had to quit doing it for myself. And actually, the last two cases I filed, I ended up having to get someone to help with it. But then I'm talking about I'm up in the R2 and the level 2 range, which is quite different and quite more intact and requires a lot more documentation.
Yeah, that's a good point. I think that when you get into the real complicated cases, as well-meaning as a lot of advocates are, and that goes for claims agents and attorneys as well. When they get really, really complicated, they're out of their realm. So I think when you get into the complicated cases where you're falling into the SMC, the M's and the L's and the L and a half and the M and a half and the R1, the R2, all that stuff, you're going to want to get an attorney or agent or even a national service officer that knows the rules and regulations real well. Because while not every veteran falls into that area of SMC and higher levels of SMC and the different precedent opinions with the court, there does come a time where you have to apply that, and so that's a situation where you're going to want to start interviewing different advocates and representatives, and I always tell people that attorneys are pretty intelligent. They have to be, to get a law degree, but just because they have a sheepskin on their wall doesn't mean they have what it takes to fight off the VA. It takes a lot of experience. It takes a lot of know-how. It takes a lot of relationships, and it takes a lot of book knowledge as well. So if you find an advocate with all those types of features, sink your teeth into him or her, because they're the ones that'll get you where you need to go.
Yeah, I was able to get up to my R1 and to my caregiver level 1 without getting anyone involved. But to get those next two, I definitely had to get somebody involved because, I turned it in, and what I turned in should have been awarded right off the bat, but it wasn't. So I had to get someone that pointed out where they had made their mistake and what they didn't look at. And when they did that, then, I won. And both of them were won in less than 12 months. So, I was quite satisfied. But I don't think if I had not gotten someone of your caliber or like you, I don't think I would have ever gotten to the R1 or R2 because it required more capabilities than what I personally have.
Good point. Good point. I think that the VA tends to try to walk all over veterans when it comes to more complicated cases. Even less complicated cases, they'll do that. But when the veteran comes into a situation where they have, especially a well-known law firm, someone they've worked with before that knows they mean business, that gets their attention, and either consciously or subconsciously, I think some of those decision review officers and or BVA judges or people that are making those decisions, they tend to think they can kind of big league the veteran, but they're not going to big league some of the more experienced advocates. So,
Yeah.
and yeah, I mean, you did well to get yourself up to R1, and it's unfortunate they didn't grant R2 with you representing yourself. It sounds like the evidence was there. It probably could have saved you the fee that maybe your attorney charged, but I think you might think that I would guess that you think it was well worth it because that person got you to where you needed, whereas you don't think you could have gotten there by yourself. So
Well, in my case, I think I could have gotten there eventually, but I think it'd probably been 36 months, not 10 months. And I think because I got him, I got it in 10 months instead of 36 months. And, yeah, that's $1,000 and, he gets 20%. That's not going to keep the lights on very long.
yeah.
But, it's what I felt like was the best way to do it. And so that's the way I went.
And you were smart. You understand that as long as you keep that appeals window open,
Mm-hmm.
your back pay is going to be even larger. So
Mm-hmm.
it's always better to get something in 10 months as compared to 36 months. Even though the back pay would be larger, we want to get compensated as soon as we can. Life is funny. We're all alive today, but who knows tomorrow is guaranteed nothing, right? So
Absolutely.
we need to hold the VA to a higher standard right off the bat.
That's what I call stacking 50s and dragging the wagon. The
There you
longer,
go.
plus, the longer you drag that wagon, the heavier it's going to get.
Well,
Tell me.
we lost your picture there a few times. I'm glad you came back.
Yeah, no, I had a couple of technical issues when I did I guess I had a power surge or something. I guess we had a storm, so we're okay now.
All right. All
Yeah,
right.
we're good. But,
John, you're kind of quiet. You have any questions at all? You want to throw anything at me?
um, you're uh, I've been pondering two other issues. Like other cases of other diabetic stuff and things like that. Of course, I've got a list of stuff I'll run your way. But tell, I mean, diabetes is a very um, I guess we say it's a very diverse disease because you've got so many secondary issues you can claim off of that one issue. And I don't think a lot of folks understand that. Because you got insulin dependent diabetes or diabetes itself, you've got all the neuropathies, you've got eye issues, you've got bowel and bladder issues, you've got small fiber neuropathy, which they don't really um, focus on too much with VA. You know, the problem is if you got diabetic neuropathy and small fiber neuropathy, they'll send you and do the test on your feet and your legs and things like that for the nerves. However, your large fiber nerves might be, operating to a good extent, but the small fibers are the ones messed up. So the rate schedule, but the rate schedule doesn't pick that out. They just consider it as diabetic neuropathy. So, I mean, there's some things in that area that, that the VA can improve on and there's a lot of things they can improve on the rate schedule. You know,
Yep.
But
From a medical side, getting a good qualified endocrinologist
mhm,
that deals with diabetes type 2 on a regular basis and all the residuals that can come along with it, including the
mhm,
kidneys and the heart and the vision and the neuropathy and the different levels of neuropathy and the nerves involved and yeah, it is something that very insidious disease. Um, I've had veterans that have had amputations. I've
mhm,
had veterans die because of diabetes. I've had I've had veterans spend times in nursing homes because of diabetes, and so if it goes unchecked and untreated, it'll get you.
mhm,
So you're right. From a medical side, it's important to find an endocrinologist that is experienced and can document everything and provide the appropriate letters and nexus letters that we can use to help win claims. And then, of course, from the raider side, they have to be up and experienced on all the residuals that go along with diabetes. Um, I know for myself, I continually try to educate myself on a variety of different diseases that come about. I mean, medical science is changing all the times, and diabetes is something that is important to learn. I know I've learned a lot from my clients over the years. Uh, John, I've learned from you.
mhm,
You've got, I won't get into details, but you've got disabilities that that maybe kind of scratch my head and think, yeah, let me research that a little bit closer. You know, let's look at that a little bit closer. And a lot
mhm,
of it I knew, but you don't deal with them all the time. And so you kind of, there's so much to remember, but then it keys your memory. And it's like, yeah, he brought up something. I'm going to research that a little bit. Yeah.
yeah,
So I learn a lot from my clients doing this 33 years. And some of your biggest teachers are your clients as well as your peers and your teachers.
yeah.
What's your opinion on take like John and myself? Here we are, pretty highly rated as far. Well, I'm more than John with the diabetes and things. However, things are continuing to worsen, and I'm continuing to lose use of my hands, for example. Now, is there any reason for me to go back and file a claim or ask for a higher or ask for an increase? The best
Are,
example, my hands are I think one's at 30 and one's at 40%. Now, realistically, that was done back prior to 2010. I think it was about 28, 2008. So they've definitely worsened a lot, and I've lost almost complete grip in my left hand. Does it even benefit me in any way to take the time and the effort and put another claim into the wheel for that
I
any
see John
reason?
shaking his head no. Yep. I agree.
Yeah, I agree too, John. I don't want to go through the
Yeah.
hassle, but some people say, "Well, why don't you put in for more? What? There's nothing else I can get."
Yeah, you can't unless the law changes. R2 is the highest you can get.
Yeah,
Um,
you need
you
to
know,
live. Yeah, you
unless
need to
you
keep that claim file closed.
unless you had a wife that was in need of aid and attendance, you might get a higher dependency allowance. There's some hospital benefits that you could get, uh, uh, not necessarily from a caregiver standpoint. If your wife was taking care of you, there's a caregiver allotment that's afforded her, and there's medical services that you might qualify for as you get worse off, uh, you know,
Not,
nursing home care and stuff like that. But as far as a monthly compensation, no, R2 is the highest
you know,
unless they change the law.
I think it would be. I think anytime you're an R2 vet, there's basically there's no reason at all to file another claim because you do not want to give them the opportunity to open that claims folder up, especially if you ain't had it a certain amount of time, at least 10 years, or because 20-year protection rule, it works, but I just hit one of my 100% just a couple of days ago, and so those protections are in there for a reason. That I would not touch anything or open any claim up. Just the higher you get rated, I wouldn't open anything else up because you never know. I mean, if they're all it takes is one person to look at something the wrong way, and you got a headache.
Yeah, and there's always the chance that I've seen it happen too, where the VA committed a clear and unmistakable error.
Hmm.
I'm not saying that's the case with you, Ray, but you could be rated for R2 or any percentage, and you poke the bear, and all of a sudden you get some bean counter that looks at it and says, "Well, we shouldn't have rated that person at that percentage at that time. We made an error, and we're gonna propose to lower that person's upper extremity from 60 down to 10 or something like that. It's
Right.
something crazy like that. It can happen. So I think that be careful when you poke the bear. Yeah, R2, there's no doubt you wouldn't. But I mean, if you're 100% permanent total and you're not drawing special monthly compensation, unless you qualify for SMC, special monthly compensation, I wouldn't touch it. I think most advocates would tell you that as well. Unless, even sometimes I get veterans that are 100% permanent total, and they think, well, I've got erectile dysfunction, so maybe I can get an extra $180 a month. I'm like, maybe, possibly, but is $180 a month worth it for them to open up the Pandora's box again? I wouldn't risk it myself, but
Unless they had
Well,
diabetes.
that's a great example. I have a gentleman that I've been helping. He actually has worsened a lot. He had not hit the 10-year mark. He was at 8 years with his feet, but his feet had gotten worse. And so he asked for an increase and trying to get from a 40% to a 60% or to an L. His ankles are locked out. Well, they reduced him. They took him down 10%, and he couldn't understand why. And I said, well, let's look at this. What did you not tell me? I asked you if you've been going to the doctor. Well, I have. I've been seeing Dr. Anderson here locally. I said, have you gone to any VA doctor? No, I didn't like him. Well, did you get VA to recommend your community care? No. Well, those are two very important things, guys, because if there's no record in a year that you've received treatment, these guys in the VA are going to assume that you have improved your condition. And they're going to lower you. I mean, it was only 10%, but then what I've had encouraged him to do is ask for a hearing because that's taken 3 or 4 years. And that gives him enough time to get back into the VA and get updated documentation about how bad his ankles are and also getting prosthetics. And I'm sure they won't reduce him and they may give him the increase that he was seeking. But
He should have got the records from outside doctor and turned them in and say, no, you don't.
well, that's a good point, but he didn't. And so now he's going to do that.
That's
Yeah,
on him.
now he's going to do that, but right. But he seen the less they have to do with the VA, the better they like it.
Yeah, but
you got to be careful. You
you
got to
got
be
to play the
careful.
game. You got to play the game, Ray. You know that.
Oh yeah.
You don't play the
That
game.
that 10 20-year rule, if I remember right, if after 10 years they could never reduce you, and after 20 years they could never sever you, if I remember right.
20 years is the only way they can sever you, and only way they can either sever or even touch it really is due to fraud.
Yeah, yeah.
So
So those are things to keep in mind as well.
mhm.
Uh, but well, how would a Q apply to that though? Because I tell you, I'm confident I've seen cases where the guys have been rated for a number of years, but they come in and they do something with their claims and they realize that back condition that they had rated 40% should have been rated 10%. I seen them monkey with that too if it's a queue.
Mm. Well, Q is a different issue too because Q goes back to the date they whenever it arose. So if they made a Q in an original claim and the guy had it for so many years, they found a Q, then I guess they can take it.
It could,
Yeah,
but
and I
that's
think that's held up in court too. So it's I mean they can do that. It was a mistake, but it also depends on one thing too. Now, if there's a Q and if it didn't affect the overall service-connected disability, say if a person's a stacker and he's got 100 plus a SMC plus he's got 300 or 400% more of the different ratings, and whatever he does, the reduction or whatever he makes is going to affect his rating. They usually leave it alone,
yeah,
you know. So, but
yeah,
unless you're me,
yeah, yeah, yeah. The story's yet to be told. Um,
yeah,
but
Mhm.
yeah, we covered a lot.
Yeah, we did, man, we did. But, yeah, we'll cover it again next week too, though. So,
So what's
no,
on tap next week? Who's going to be your guest?
I've got a couple of ideas. I haven't had any confirmation yet as far as the actual guest itself, but uh, for anybody listening, say a little prayer for Mr. James Cripps. He's under the weather pretty bad, and he's going to need all the prayers he can get his hands on because this time he's got some serious stuff going on.
Yeah,
Yeah.
yeah,
So,
yeah. I agree. I agree.
yeah. So, but Ray, I'm glad you made it, buddy. Yeah. And the Bears didn't get you all up there in Eastern Tennessee. Hmm. You need to take a trip up to Stacy Home Place in Perry County, Kentucky. You want to see some elk? Yeah, on trip golf, they got plenty of elk on them right there. And but it's on that's actually it's on our land, so we can go up there and check it out.
Yeah.
Hmm. Well, listen, guys. Thank you guys for coming on, John. You always, man. I know you're retired and you don't take any new clients, so but we're still gonna milk it for all it's worth, buddy. We're gonna keep you on as much as we can. So until
Sounds good.
you give it up, you know.
Thanks for having me on. Hopefully, I
All right,
helped a little bit.
take care of that grandbaby, buddy.
All right, I will.
All right,
Thanks,
folks.
guys.
All right, folks. Thanks for listening to the show. We'll be back again next week. This is John on behalf of Ray and Mr. John Dorle. We'll be shutting her down for now. Right.